What's up, guys? It's Clint Coons here, and in this video I want to discuss the differences between a land trust and a living trust. Okay, let's get started. Now, I get a lot of questions about what is the difference between a land trust and a living trust when it comes to assets, asset protection, holding real estate. I can tell you this, there's a world of difference between these two. However, when it comes to referring to these trusts, we don't want to draw those distinctions when we're dealing with third parties. Now, this can get confusing for a lot of people who have set up living trusts, who have set up land trusts, or they're considering setting up one of these tools. You know, how do I refer to it and what is it going to do for me? So let me just break this down for you. Now, a living trust, okay, what is it? What is a living trust? A living trust is an estate plan, okay? So what that means is that when you put assets into this, think of this as a big box that you're going to create. And it's designed to hold more than just real estate. You want to put inside, maybe you put your personal residence in here. You can put your vehicles into your living trust. You'll put your personal checking account into the living trust. Maybe you have a boat. You'll put your boat into your living trust. All of your personal assets are going to reside in this living trust. Now, the living trust is also referred to as a grantor trust, okay? Now, what that means is that you've created it. You're the grantor, you're the trustee, and the beneficiary of this trust. So it's a self-settled trust. You've set it up. It's ignored for federal tax purposes. Everything flows down to you. And you've held assets in the title of the trust itself. And nothing really happens with the trust until such time as you're incapacitated or you pass on. Now, when that occurs, if you're incapacitated, someone else steps in and controls these assets for you, or when you pass on, then your assets that are held in this trust are going to be distributed down to whoever your beneficiaries are, or they go to your spouse or something like that. So a living trust operates as an estate plan. It's designed not to do anything really with your assets until you're in a state where you can't make decisions for yourself or you've passed away. A living trust can't be transferred to someone else while you're living. You can't say, you know what, I want to give you 25% of my living trust. That's not the way it would work. With the living trust, if you wanted to give someone 25% of your assets, you would actually have to transfer your assets to these individuals directly. So you would just pass them the assets. And so by doing that, let's say it was a piece of property, you got to record a deed. So there's a public document that's recorded showing the transfer from the trust to these people here. Now, a land trust is different than a living trust. Now, a land trust is a grantor trust in that when you create a land trust over here, yes, you are setting up the trust where you're the trustee and you're the beneficiary and the grantor, but this is a title holding trust. Okay. Now, as a title holding trust, this land trust, it's still a grantor trust, just like the living trust. And that's why many times when we refer to these trust documents, we'll tell people if you're dealing with a lender, if you're dealing with the bank, if you wanted to open an account or a title company, you're going to tell them, if they ask you, what type of trust do you have? You don't tell them you have a land trust. You tell them you have a grantor trust. Same with the living trust. You always tell them you have a grantor trust because we want to create the presumption that both of these trusts are equal, that you set something up for estate planning. But really, that's not the way the land trust is designed, because with the land trust, it's similar to the living trust. You've got a trustee, which is you, and or an entity that you own, and you've got a beneficiary, which is you, right? Just like we have in the living trust over here. Now, the difference is in the design of these trusts, because trusts are like contracts. You can set them up with different provisions reflecting the desires of the grantor when they create the trust. And that means this, that we can set it up so that the beneficiaries in a land trust have the ability to transfer their interest at any time. So think of it like stock in a company. You can transfer stock to someone. Well, a land trust is set up where the beneficiaries can transfer their interest. Now, if they don't, we also have estate planning provisions built into a land trust that whatever you own at your passing, if you're the owner, it could go to your beneficiaries or it could be distributed over to your estate. So you really got both built into the trust, whereas here it's just purely estate and you can't assign anything while you're alive. That is the trust. Over here, You've got the estate aspect of it if you're holding it when you pass away, which you shouldn't be. If you watch my channel, you'll know that your land trust should be in an LLC. But the other thing about that land trust that we like is that if you did decide to transfer that trust or those assets, let's say I had a piece of property in here and I want to get that property to my kids today, but I don't want people to know about it. All I would have to do is transfer my son and daughter my beneficial interest. I, Clint Coons, hereby assign my beneficial interest in my land trust to my kids, and then give them that assignment. Now they're in charge of the trust. I would resign my position most likely as trustee. I don't have to. My LLC could stay on there as trustee, but the point is they now become the owner of that trust, which by de facto makes them the owner of the property. That is not recorded. No one knows about this transfer. Whereas if we had that same property right here in the living trust, as I told you earlier, if you wanted to get that property over to your beneficiaries, you would have to deed it. And that's going to be a matter of public record. So when it comes to setting up land trusts, what we're going to be focusing on, is this ability to transfer our interests. And that is the main distinction between a land trust and a living trust. But now that you know that, if you have both or you just have the land trust and you're operating with third parties, I highly encourage you to always refer to these as grantor trusts. And if they ask, why did you create this trust? Tell them it was for estate planning. Nothing you're saying there is incorrect. It is a grantor trust and it was set up for estate planning because there's an estate planning aspect to it. You just don't have to use it that way. And the reason why you want to say this and make people think these are the same things is that there's much more familiarity with third parties with living trusts than there are with land trusts. So we want people to assume that because then it invites fewer questions. Now, of course, if they ask for a copy of the trust document, well, now the gig's up and they're going to find out, hey, this isn't really what we typically expect, because they're going to look at that language which allows the beneficiaries to assign their interest, and they're going to say, hey, what's this? And then you're going to have to explain it. Now, there's ways to even get around that. I've got a video on land trust about dealing with lenders, how you restate it to make it look like a traditional living trust. You should check out that video. But that in a nutshell is the difference between a land trust and a living trust and why people use them. Guys, if you liked the video, make sure you hit the like button. If you haven't yet to subscribe to my channel, now's your opportunity to smash that button as well and become a subscriber. Take care.